India is a federal country. The Indian Constitution establishes a two-tier governmental system with the central government at one level and the state government at the other. The Constitution has devised an elaborate scheme of distribution of legislative, administrative and financial powers between the center and the states. The governments are entitled to act within their assigned field and cannot encroach on the field assigned to the other. In their assigned field, they are completely autonomous and independent of each other. In order to consider a country as a federal type, certain essential features must be present. They are division of powers between the two layers of the government, written constitution, supremacy of the constitution, power of judicial review, and a rigid constitution. In this presentation, we shall examine as to how far these features are present in the Indian Constitution. Let us now consider the essential federal features of the Indian Constitution one by one. The first and the foremost feature is the division of powers. The Indian Constitution is a federal type. It establishes a dual polity, a two-layer governmental system with central government at one level and the state government at the other. Under the Constitution, there is a threefold distribution of legislative powers between the Union and the states, provided by the three lists in the 7th schedule of the Constitution. The Constitution creates three functional areas: one, exclusive area for center; second, exclusive area for states; and a common or concurrent area in which both the center and the states may operate. Article 246, Clause 1 of the Indian Constitution confers exclusive power on the center to make laws with respect to any of the matters in the Union list, that is list 1 of the 7th schedule. Then Article 46(3) confers an exclusive power on the states to make laws on matters enumerated in the state list. And Article 246, Clause 2 confers a concurrent power of legislation on both the center and the states with respect to matters enumerated in the concurrent list, that is list 3. However, on matters in the concurrent list, overall supremacy of the center has been established. Thus, under Article 254, it is provided that if there is any conflict or repugnancy between a union law and a state law on a matter in the concurrent list, union law will prevail over the state law. Let us now consider broadly the nature of the three lists. The list 1, that is the union list, is the list which consists of subjects of national importance, and on these subjects the union alone can make law. And this union list consists of subjects like defense, foreign affairs, war and peace, citizenship, extradition, railways, banking, interstate trade and commerce, etc. List 2, that is the state list, which consists of 66 entries, comprises subjects which are of local and state importance. And on these subjects, only the states can make law. And the state list consists of matters like law and order, police, public health, agriculture, fisheries, state taxes, prisons and others. List 3, which is popularly known as concurrent list, comprises 52 subjects or items of legislation. And in this concurrent list, subjects of common interest both to the center and the states are included. So both center and states can make law on the matters which are listed in the concurrent list. And this list 3, the concurrent list, includes subjects like education, criminal law, civil procedure, marriage and divorce, trust, forests, population control, factories, electricity and others. And actually, under the Indian Constitution, these 3 lists consist of actually almost all the subject matters of legislation. But if any subject matter which arises which is not included in any of these 3 lists, then on such a subject matter, under Article 248, Parliament has been vested with the power to make law. And this power to make law is called as residuary legislative power. The most important requirement in a federal system is a written constitution. Indian Constitution is a written constitution. It is a lengthy and detailed document. Today, after so many amendments, it has 441 articles and 12 schedules. Being a federal constitution, it has provided for detailed provisions regarding center and the state relationship in order to avoid any uncertainty and confusion regarding their respective powers. The Constitution has provided for the governing structure both at the center and in the states, and the totality of governmental powers are distributed between the central government and the state governments, and they are recorded in the Constitution. Being written, the Indian Constitution acts as the standard of reference for the authorities to resolve any conflict between the center and the states regarding their mutual claim over the exercise of any powers. The next important federal feature is the supremacy of the Constitution. Both the central and state legislatures derive their powers from the Constitution. Their exercise of powers must be logically subordinate to the Constitution. The Constitution is the fundamental law of the land. It is under this fundamental law that all laws are made and executed. All governmental authorities act. No legislature can make law and no governmental agency can act contrary to the provisions of the Constitution. Article 245 has clearly laid down that the legislative powers of the center and the states are subject to the other provisions of the Constitution. Similarly, Article 13 provides that any law which is inconsistent with fundamental rights would be invalid to the extent of inconsistency. Thus, the supremacy of the Constitution is emphatically secured. The next important federal feature is the power of judicial review. The Indian judiciary has been accorded a dignified and crucial position in the Constitution. The Indian Supreme Court is the general court of appeal from the high courts, and it is the ultimate arbiter in all constitutional matters. The Supreme Court is entitled to scrutinize any law, any governmental action, in order to assess whether or not it conforms with the Constitution. The Supreme Court acts as the guardian and a protector of the fundamental rights. A person complaining of a breach of his fundamental right can straightaway invoke the court's jurisdiction under Article 32 of the Constitution. The apex courts acts as the supreme interpreter, protector and a guardian of the supremacy of the Constitution, and the Constitution explicitly establishes the doctrine of judicial review under its various provisions. Thus, the supremacy of the Constitution is protected and guaranteed by the judiciary through its power of constitutional review. The last essential feature of a federal constitution which we are going to discuss is the rigidity of the constitution. A constitution which cannot be amended easily is characterized as a rigid constitution. The Indian constitution is amendable not by ordinary legislative process but by a special and elaborate procedure. The Indian constitution can thus be characterized as a rigid constitution. Especially, the federal provisions of the constitution cannot be amended by the parliament without the ratification by states. In view of the above 5 factors which are present in the Indian constitution, it can be characterized as a federal constitution.